All right. Hello, everybody. My name is Gabby. I am our Community Education Outreach Coordinator here at Legal Aid. With us today, we have Sarah Carafa, one of our attorneys here with us at Legal Aid. Sarah, correct me if I'm wrong, you're based out of our Raleigh office, correct?
Correct, yeah.
Yep. So Sarah's going to be presenting today on child custody in North Carolina. If you're unfamiliar with our Listen and Learn webinars, again, what's going to happen is Sarah's going to go through a child custody presentation with all of us, and then we're going to strive for a Q&A today, but are being mindful of some time constraints. So have your questions prepared. You can put them into the Q&A box. And again, if time permits, then we are going to go through a question and answer portion. But the goal is to get you all of the information you need to do this successfully on your own. So with that in mind, if we do have a question and answer session, if we get to that today, your questions do have to remain general. Sarah is an attorney, but she's not your attorney. So, we're not going to be able to provide any sort of specific information pertinent to, your individual situation today. So keep that in mind when utilizing the Q&A box and putting your information out there. This is also not a confidential forum. Anybody can see your questions at any time. It's also being posted to our social media profiles. So again, just be mindful of the information that you're putting out there. But again, this is an informational session on child custody. So we want to thank you all for joining us today, and thank you to Sarah for presenting. And we're going to go ahead and let her get started.
All right, thank you so much. So my name is Sarah. I've been with Legal Aid since about 2017, and I work pretty exclusively inside domestic violence and custody court. So today, really, we're going to walk through what custody is, how to get it filed and started, and then what to expect once you do get to court. It's pretty comprehensive. So what does Legal Aid do? Lots of things. We are in every county across the entire state. Our main types of cases are related to domestic violence, housing, employment, like wrongful termination, education law, disaster relief, and consumer, with some mortgage and other issues. We don't do any criminal work, but we do cover just about everything else in the civil domain. So if there are other issues that you do have, and I'm sure we'll have this later on, there's a 1-800 number you can call, ask questions, see if you might be eligible for assistance for one of a myriad of different types of legal assistance. Okay, so we have all these listen and learns. Simple divorce and child custody are the ones I'm most familiar with, but we also have the basics of expunging your criminal record, rights for tenants, Social Security, Medicaid, food stamp information, and we also do healthcare power of attorney and living wills basics. So if you're interested in any of those others, I'm sure you can jump on our Facebook page and see when each of these is scheduled and sign up. Okay, as stated before, we do not represent you, so any conversations we have today are not confidential. Everybody's going to hear them, and we can't get into the details of your case. We are trying to present to you the whole picture of custody from beginning to end so that you yourself can file and be an advocate for yourself. It's called being pro se, is when you do not have a hired attorney there representing you on your behalf. And it is very, very possible in custody court to go at this without the assistance of an attorney. It happens every day. The judges are all very familiar with it. They are helpful, and they will guide you through the process as long as you are there willing to listen. So please know that this is possible. If you've already filed for custody, then much of these filings that we're about to discuss is going to concern you. If you are looking to make a change to any custody case that already exists or to any orders that exist, you would need to file what is called a motion to modify custody. We're not going to go through any form that discusses that today, I believe, but it is a simple, straightforward form that you can get and complete if you need a change to what is currently ordered. Okay, the law. If you want to go and peruse the particular laws surrounding child custody for the state of North Carolina, you can do so. You can just type in NCGS Chapter 50, Chapter 50A to get all sorts of specifics. on the details of who can file, when they can file, what they're filing for, and how the judges make their decisions. So we're going to go through some of these definitions because they're things that you're going to hear over and over and over. The most important and the main standard for two parents fighting over custody is the best interests of the minor child. So if you are in court with the other parent or with a non-parent third party, under some circumstances, your judge is going to be asking the question, what's in this child's best interest? The case is not necessarily about who is the better parent. That's not how the decisions get made. It all goes through the lens of what is best for this child based on everything that I'm hearing in both of these parties. So this term is just going to be drilled over and over and over in any court proceeding. Non-parents, third parties, also have the ability to file for custody under more limited circumstances. And in the event that somebody other than a parent files for custody, they have to prove a lot more, including that the parents are both unfit, which is challenging. And it takes quite a bit more evidence and information for a judge to consider granting somebody who is not a parent custody rights of a child. I would definitely get some advice and counsel if that is your set of circumstances right now, because it's quite a bit more difficult, largely because parents have constitutional rights to raise their children. And so in order to take that constitutional right away, you have to do a lot more evidence and support your case pretty clearly. Terminology. So we have plaintiffs, defendants, pro se. Plaintiff and defendant are typically the two parents. It doesn't matter who files when necessarily. In some types of cases, being the defendant is a bad thing. In child custody court, it does not particularly matter. You just need both parents named in whatever way, whether plaintiff or defendant. It's not something that the judge is going to judge for or look down upon. The judge just needs to know that both parents are there. Okay. Who can sue? Obviously, both parents. Both biological parents, whether they are named on the birth certificate or not. If they're the biological parents and there's not a dispute, both of them can file for custody. Relatives can also file, like I was discussing in terms of being unfit. You might have a grandparent, an aunt or an uncle that has raised the children because the parents are gone or there's something serious going on with mental health, substance abuse. So a third-party family member might be able to file for custody as well, along with agencies and institutions, child protective services, who have been involved and have an active investigation or case pending. They also have the right to sue, although this happens in much fewer circumstances. You're going to be filing in district court in either the county where you reside or the county where the child and the other party resides inside the state of North Carolina. Think about where you want to file, in part because you're going to be making a lot of trips to court. So it's going to need to be somewhere that is accessible to you and that you're prepared to drive to at least a handful of times before resolution. We'll talk about remote and COVID-19, how that's impacted the courts, but it is different county to county. So you're going to need to know the county that you're filing in and kind of some of its practices. And you can ask the clerks about that. So when do you file? Most often it's when you separate from the other parent. However, there is one major limitation, and that is that the child that you're filing on behalf of has to have lived in the state of North Carolina for at least 6 months before you file the claim for custody. If you have moved here from another state and it's been 2 months, it's very likely that this case won't move forward, and the judge will tell you to go back to the state that you were living in and to file there, because the child's residency is a little bit different than how we define it when we move here. They have to have been here for 6 full months. And that's sort of question number 2 and 3 when you do file your complaint, and we'll look at all of this as well. But that is number 1 requirement. All right. What are parental rights? Parents, mom and dad, pretty much have equal rights in the eyes of the law until a judge says otherwise. So it doesn't matter if one parent has had the kid for 360 days out of the year and the other parent has seen the child for 5 days out of the year. That parent who has had the child for 5 days out of the year can withhold the child and keep the child with them because they have equal rights to the child. And oftentimes that is an issue that occurs, especially in my practice, and it is the impetus for a parent needing to file for custody. It's because the parents aren't agreeing when, how long a child is going to spend time with the other parent. And there's nobody that's going to police that, including the local police departments. They will not swoop in and remove a child from a parent's arms without an actual order telling them to do so. And there's a process for getting those orders, but it's a lengthy process. And filing for custody speeds it along so that you have an order in place telling law enforcement who gets the child when. So no custody order, the police aren't going to intervene. Also, know that if your parental rights have been terminated, you're not going to have the ability to sue for custody. You will know if your rights have been terminated. It's a process taken up in juvenile court. Most of the time you are given an attorney, and there is a series of proceedings in which a judge determines whether or not your rights should be terminated. You'll know. Just because you haven't seen the child in 4 years, didn't know the child existed, does not mean your rights have been terminated. As long as you are still a biological parent of that child, you have a right to sue. Finally, we have child support and child custody, which are 2 separate claims. You can file and request both of them at the same time. You can do them separately. It does not matter. But custody is decided differently than child support. There are different rules. There's different definitions and language. All right, so what are you seeking? Here are the primary terms. Joint custody is when both parents share custody. There is joint legal custody, which is major decision-making authority. This is most often given as joint. A lot of parents want to have sole legal custody, very hard to achieve. Most judges, at least in my experience and in the counties that I practice, are going to give decision-making authority to both parents, and they will require that both parents work together to make decisions for the best interest of their children. No one person gets to decide medical care, education, spiritual upbringing. Those questions have to be decided by both parents. On the flip side of that is exclusive custody or sole custody, where one parent gets to make those decisions, and they just, in most circumstances, have to keep the other parent informed. So they're allowed to make those decisions, sign the child up at different schools, medicate the child if they think that it's in the child's best interest. All those decisions are for one. That is legal custody. There is also physical custody, which is just the amount of time that you're going to get with your child, that each person is going to get. Joint means you're going to share it. Sole or exclusive custody means one person is going to have custody of the child most of the time, or even all of the time, depending on the circumstances. And if the judge finds that it would be in this child's interest, that only one parent have that physical custody. So in every custody case, you're going to get some sort of a schedule of time, week to week, day to day, that will be spelled out by the judge, telling you when and how to exchange your child, and when they go back before you file. Do you need to? Filing for custody means that at some point a judge is probably going to make a decision and it's no longer going to be in your hands. If you and the other parent work well together, and you can come to agreements outside of a need to file a lawsuit, stay that way. It's ideal. It allows you the most flexibility. And you don't have somebody else making decisions about your child, right? That power gets taken away when you do file for custody. It's not needed to get any child support or welfare assistance. There's a lot of things that you can get without having a formal custody order signed by a judge. So you should investigate that before you go and file for custody. Obviously, drawbacks include being very time consuming. You're going to be driving to court more than once. A judge is going to want to go into detail about your personal lives. When it comes to the best interest of your child, everything is relevant. There's nothing that's off limits if a judge is concerned. And if you're doing this pro se, the judge will be asking you questions and you will be answering them truthfully. So you need to step back and consider and reflect on yourself about what this judge is going to potentially ask you. And I think we go through this. Self-evaluation, yes. So, is it time to file? Are you employed? Do you have a place, a roof over your head, a place for your child or children to live? Do you have a driver's license that will allow you to get to and from certain places, school? Is your living situation safe? How is your mental health? Do you have any criminal issues that are ongoing, pending, substance abuse issues, or prior court orders that could impact custody? These are all things that you really want to consider before you go into the courthouse and you file for custody. In my practice, domestic violence protective orders are what precedes most of our custody cases, and those directly impact a custody decision. The judge will simply take that domestic violence protective order, and he or she is required to review it and read it, and consider it as a factor in making their decisions about custody. So you want to think about all of those other court decisions that might be out there. Convictions, drug convictions, convictions for assault, those types of things. They're also going to be considered by the court. Likewise, the same is going to be considered for your ex-partner. So consider all of this before you go into the courthouse and file. Do you need a lawyer? Is your significant other going to fight you? Do they have lots of money to file motions and arguments to tie you up, to add cost and length to this process? Are they going to be able to hire a lawyer themselves? That could have an impact on you. It doesn't necessarily mean by any means that you're going to be losing significant rights to your child, but you are going to be up against somebody who is more competent and knowledgeable of the system. And it's going to take a lot more effort. It doesn't mean that you are going to lose rights, though. It's just going to take more effort. You should get a lawyer if there is an attorney and it is contested, especially if it's a very highly contentious separation. If there are allegations of abuse against the children and you can manage getting an attorney, you absolutely should. And go through your custody packets. We're going to walk through it today and consider it, and consider if you can after you've read everything and after we've gotten through all of this. All right, so what are we going to do? We're going to walk through the forms, how to file them, how to serve the other party, and then the process once you have the other party served and you're going to court. All right, there's a handful of forms that you can Google, and they're on the NC Courts website, and pull up the PDFs, print them out, and fill them in. They are all fairly self-explanatory. We'll walk through them. I'll show you examples of many of them. There's also a packet that we have. I'm not sure if that was given to you guys. but you can find it online as well that has all of these forms. You can do these either on the computer and print them out or just clearly and legibly write in black or blue ink. And you're going to need 3 copies before you file them. One is going to go in the court file, that original one. One is going to be kept by you for your records. One is going to go to the defendant and be served on that defendant. So before you get to the courthouse, you're going to need to have completed all of these forms and copied all of these forms and have at least 3 copies with you moving forward. 1 through 6 are all the main forms that we're going to go through. There are others here and there based on each county. So once you do file these initial forms, you're going to want to ask the clerks if other forms are needed. They'll be able to guide you to that, whether it's online or whether they have copies. So once you get to the courthouse, talk to them. All right. This is the website for accessing forms online. You can literally search family, child custody, keywords. You can also put the forms inside of the form number box. These forms back here, AOCCV 609, these will all pop up specifically when you search on this website. So it should be pretty easy for you to get to. Okay, let's talk about the petition to proceed as indigent. This is the form that legal aid uses all the time. There is a cost associated with filing for child custody. I want to say it is $150 for an initial filing. After that, there's very few costs associated with the custody action, but that first $150 is a lot. And if you can't afford it, there is a form that you can complete. There are 2 different forms actually, to ask the court for permission to file without paying. If you're receiving services from legal aid, if we are representing you, this form can be filled out by both us and you, and the court will accept a custody filing without this $150 check. The court also will accept it if you're receiving food stamps or Social Security income. And there is a secondary form as well. If you're not receiving any of these, but you are making very little money, there is a petition as well that you can look up. I'll see, I might have to put it in the chat. And it will ask you to go through your monthly expenses. And if you meet a certain requirement, the clerk is allowed to accept your custody action without taking the money, even if there's no food stamps, no SSI, no legal aid. So it's very possible that this will all be waived for you. Obviously, don't lie on any of these documents. When you sign these documents and you file them with the court, it's like you're testifying at court. So making anything up is not in your best interest. It's not in the child's best interest. And if you get caught, there can be serious repercussions. At minimum, if you're lying on any of these forms and a judge figures it out, they're going to find you just less credible. They're not going to trust what you say. The petition to proceed as indigent is one of a handful of forms that you're going to have to sign in front of a notary. I know that UPS does it. I know that some banks do it. The courthouse does not. So be mindful of that because they're not going to notarize your documents. All right, here's the petition itself. Your name, defendant's name, county. You'll be given a file number when you go to the courthouse. And here are all the different boxes you might be able to check, followed by notary and your signature. Civil summons. This is what has to go on top of everything when you serve your partner or your ex-partner with these documents. This has to be on top, and it needs to be signed by a clerk. So this is one of the forms that you're going to bring copies of. I think I'm going to just go to the next page and just walk through it. Again, you're going to need to put your name and address, their name and address, the county. The file number is going to be completed when you are in front of a clerk completing it all. And the clerk is going to come down here and she's going to issue it. Just date and signature here. And once that happens, you'll be able to either mail it or serve it with the use of a sheriff. So you're going to want to have probably 4 copies of these. You only need 3 if you're going to mail it to the defendant, but you're usually going to need 4 if you're going to use sheriff. We're going to go through how to serve the defendant shortly. Just checking that I have gone through everything. If you do have an attorney, there is a box for putting your attorney's information as well. All right, the complaint. There is a pro se packet. You will find a complaint in there. There might be different versions of them on different websites for North Carolina, but all of them are largely the same, and they're fill in the blank. It is done very simply, so you can impart all of the information that's needed, notarize it, and file it. Let me walk through parts of it here. Again, we have the parties' names. You need to tell the court what county you're in, what county you believe the defendant to be in. You need to tell them what your relationship is. Doesn't matter, don't have to be married, just need to be able to express what the relationship is, whether there was a marriage or a divorce. You need to be able to list the children, all of their names, dates of birth, ages, as well as the addresses that these kids have lived at for the past 5 years. You have to go back 5 years. There is a form for this that we will also go over. There's 2 ways to do it. You can do it inside of this complaint. You can also do it on a separate form. But it is fill in the blank and fairly straightforward. Page 2, if you've litigated custody in another state or in another courtroom, if you have a domestic violence protective order that has made decisions about custody of your children, you're going to want to make sure the court is aware of that. So you're going to list those, the name of the court, the case number, and when that was decided, because the judge is going to want to be able to review based on that information as well. If anyone else has any rights to custody of these children, you need to make the court aware of that. Maybe there's not an order, maybe you're not sure, but there might be another person out there that has rights listed here. Finally, towards the end, you have your assertion that you are fit and proper to have custody of the kids, physical custody and legal custody, that you're unable to agree on custody with your partner, your ex-partner, and that this court has jurisdiction over these kids. Jurisdiction is, have these kids lived here for 6 months preceding this being completed. They need to have it. That's the box you check saying, I swear we've lived here at least 6 months. North Carolina, you're the place to make this decision. It's not any other state. That's why we're filing here. And down below, we have a request for temporary and permanent custody. Generally, the court will bring you in quickly, make a decision on temporary custody, and then bring you in 6 months to a year afterward to make a new decision on permanent custody. You want to have a temporary custody order in place as quickly as you can, because that decreases the likelihood of arguing, fighting over custody. So the courts are trying to pick up speed and get you in for temporary hearings, which are short, 2 hours in Wake County. And then they'll bring you back in for permanent custody after a period of time so that you have more time to have a hearing if needed, and so that the court has more information about custody of the children before they make a permanent decision. Down here, you're going to sign, print, you're going to notarize all of this, swearing that everything that you just completed in the pages above is true, is accurate, you're not lying. All of this is correct to the best of your knowledge. And the notary is here. Okay, the affidavit of status of minor children is also a form. It's inside of that custody complaint we just went through, but it's also its own form. You can choose to do either, but you need to have it somewhere. And each child is going to get their own form. This is what the form looks like. You can Google it, AOC CV 609, and you're going to complete parents' information, name, date of birth, place of birth, and you're going to list every address over the last 5 years that the child has lived and with whom. You're going to have a notary sign it, you're going to sign it, and you're going to look through these boxes, and again, like we were just discussing in the custody complaint, you're going to check boxes if you know that there's been litigation or other court decisions about the custody of these kids. You want to make sure this court knows about them. Don't want to hide the ball, because depending on what those decisions are, the court may be unable to hear it, or they might have to take into account that previous decision. Domestic civil action cover sheet is fairly straightforward. You're just going to complete, let me just switch to it. There we go. Your name and address, their name and address, and what you are filing. You are filing a complaint for child custody. Those are the boxes you check. We're not covering anything else. So if you check other boxes, you're going to have to file separate complaints and separate lawsuits for those particular claims for relief. So today we're just talking about you filing a complaint for custody. If you already have a custody order and you're asking to modify it, we're talking about a modification of custody right here. But those are the two things we're talking about today. All right. There's also mediation. It's mandatory in North Carolina that every parent at least attempt to mediate and get a decision on custody without having to have a trial in front of a judge. There's a lot of folks that can and are able to navigate it and reach an agreement with the assistance of a mediator. In Wake County, it's done virtually. In other counties, it's done live and in person. But it's going to be scheduled before a trial once you do file for custody. So there are forms associated with the mediation. This is a Robeson County form. Different counties have different versions, but really they're largely the same. They're just giving the court clerks information about how to contact you or your attorney, the defendant or their attorney, the children's names and ages. And the family law clerks will use this to schedule a time for the two of you to attend a mediation and try to reach agreement without a trial. Civil Service Members Relief Act. This is required for every filing, whether it's a motion to modify custody or it's a custody complaint, a new one. It no longer needs a notary. Let me see if I can get this. And the purpose of this form is to tell the court if you're filing against somebody who might be deployed or who might not be able to make it to a custody hearing because of their service in the military. So if your spouse, your ex-spouse, has been in the military, you're going to want to sort of walk through these questions up here and tell the court, oh no, okay, why your significant other is available or is not deployed somewhere. If your significant other has never been in the military, you can simply write right down here under 4. I have known this person for 15 years. They have never served in any military service. I've never heard them talk about it. That's enough. That's all you need to write in here. If your spouse has served in the military, you're going to need to go to this website and run a simple, easy check, and it will print out a certificate for you to file saying this person is not stationed in Germany right now. And that will be attached to this. The website is very straightforward. It shouldn't cause anyone any issues. I've done it many times, and it just requires names, birth dates. I don't even think it requires social security card or social security number. I think it's a name and a birth date, and it just runs a check for you. You're going to sign it, date it. That's all you need to do with this. All right. So you're going to take all of these to the clerk of court. In Wake County, it's on the first floor. You're going to walk into the clerk's office. You're going to have at least 3 copies of all of these documents. You are going to hand them over to the clerk, and the clerk is going to review them, approve them, and stamp them all, showing that a lawsuit has now been filed. They're going to give you your case number, and they're going to give you 2 sets of copies back for you to both have for yourself and to give to the other party. The file number is critical and important for searching or receiving any new documents from the other party. It's going to be written at the top of every single document that you bring in. How do you pay? If you're not petitioning to proceed as an indigent, please know that they're not going to accept personal checks. Cash or money orders is the way to go. They're not going to break money for you. They're going to need an exact amount, something simple and easy. They're also not going to make copies for you, so know that as well. Finally, clerks know the filing process, but they really can't give you instructions and legal advice. And they're very often asked for legal advice. They can't give it. So they're going to stop you and tell you to consult an attorney if you're creeping into the territory of getting legal advice. What they can tell you is how to file. All right, there's 3 ways to serve. 2 are primary. You can't just hand them to the defendant and then show up to court. There has to be formal proof inside of any custody filing showing that that particular person has received the documents properly. The first way to do it is by sheriff. In Wake County, you file and you walk across the street to the sheriff's office. You hand them copies of everything and you say, please drive these documents to this address where my ex lives and hand them to my ex. And that sheriff will do so as long as your ex answers the door. And then the sheriff will sign documents, bring them back to the clerk, and enter proof that they were served properly. So if a sheriff is able to do it, whether that's going to a place of business, your ex's job, his home, his or her home, anywhere where you know they'll be, where a sheriff can just hand these to them, that's sufficient. You don't have to use a sheriff. Sheriffs do have a cost of about $30. You have to pay $30 extra to have them personally do it. If you're indigent, you won't have to pay. But if you're not, you're going to have to pay that extra. Certified mail is the other option. You can go to the post office. It's about $8 instead of $30, and you get this green card. Have the post office worker help you fill it out, and it will be mailed. And when your ex picks everything up at the post office, or when they are handed these documents, they are required to sign this green card. And this green card gets sent back to you for you to prove to a judge that this was properly served. You need that signature and you need a date. You need to be able to show the judge, hey, I served it. They signed here. They signed on this date. They got all of the documents. Those are the 2 main ways to serve. The third way, publication, is when you have no idea where the other person lives. This is a process and it's costly. It requires a lot of research. It requires you to run advertisements in legal journals in the city and the state where you're filing. It can cost quite a bit of money. The last time I did this, it cost about $800. And it's a last resort. You can't just do this. You need to know where the other person is. Or you basically need to get the court's permission to do this by publication. And again, that's a last resort. You'll need to be able to testify and swear to the court that you have done your due diligence, you've searched everywhere, you've talked to family and friends, and you cannot find the other person. And you have run these advertisements in legal journals. If you do not have proof of service, you are not going to have a custody hearing. The judge cannot do anything, cannot move forward until that judge knows that the other parent knows that this is happening. So it's critical to serve them. We've covered all of this. Service by sheriff. Under both of these circumstances, you are going to take a copy of everything and just mail it or give it to the sheriff in a packet, and they are going to hand it to the defendant when they can find them. Certified mail. When you do get this green card back with a signature, you actually physically bring it up to the courthouse with another form, an affidavit of service. You can also find online. You can just punch in affidavit of service, North Carolina, and it'll pop up with a form. And you file it in the file, just like you filed everything else. And when the judge hears your case, the judge is going to open that file. The judge is going to see the green card, the affidavit of service, and the judge is going to know that they can move forward whether the other person is there or not. This is the affidavit of return of service by mail, certified mail. So if you use the green card, this is what you're going to want to fill out and file. Okay, what's next? The other party has 30 days to respond, written response, and they will have to mail that response to you as well. That other person might do nothing. You don't have to respond at all. You can just show up to the hearing. That other person might ask for more time to hire an attorney to file a formal response. That could happen as well. The other party could also file counterclaims against you, whether it's custody, child support, distribution of property. All of these things can be determined by a family judge. So one of many different things could happen, and it's very specific to your circumstances. As discussed before, the case is automatically set for mediation, and you'll be given instructions by the court after you've filed on how to be present at the mediation and what the mediation is going to look like. In Wake County, it's about 2 hours and it's virtual. It's a process where there are no attorneys allowed. It's just the parties, and the mediator is there not to tell one person or the other that they're right or wrong, simply to see if they can help reach a consensus, get an agreed upon schedule, get an agreed upon decision on decision-making authority, all of those things. If one person is being ornery, abusive, out of control, loud, the mediation's automatically going to stop. It's not going to go any further. The mediator's job is not to calm that person down. They will just stop it. They will say you will see a judge, and you will have a court date upcoming in which the judge will make that decision for you. If you do reach an agreement, that mediator is going to draft up a formal custody order, send it to both of you for signatures, and then give it to the judge, and the judge is going to sign it and enter it as a custody order, just as if you'd had a trial. Here is a standard visitation schedule, but I can tell you that visitation schedules range greatly in Wake County. The mediator is going to help you navigate this. If you both live 5 minutes away from each other, you're in agreement. You might have a schedule where on week 1, they're with you. On week 2, they're with the other parent, and they go back and forth. It depends on what you're willing to agree to. If mediation fails, you're going to have a hearing, and the judge is going to decide. There's a few more forms that you will probably be prompted to fill out. In Wake County, when you file for custody, you're automatically given a scheduled time for a temporary custody hearing. In other counties, it might be a little bit different. You will ultimately have to just make sure that you have your case on the calendar for a particular day, and that you've completed a notice of hearing telling the other parent when that's going to be. Everybody has to know. This is an example calendar request out of Alamance saying what you need, who your judge is, when you're going to need it, how long it's going to be, and you sign and date and you mail it to the other party. If you want to stop your claim for custody, if you are the person that is filed and you don't want to deal, mediation has failed maybe, but you don't want to have a hearing, you can dismiss the case. It's your lawsuit. You can do that at any time without punishment. You're going to lose that $150, but you're not going to be punished for doing so. It will stop the trial. It will basically take the file and close it. You should strongly consider not doing it. If you're the defendant in an action, somebody has filed against you, you are not able to just dismiss. It's their lawsuit now. So if you are the defendant, you're not able to simply dismiss and walk away. Preparing for trial. Be on time, 100%. Dress appropriately. You don't have to wear a suit. Nobody wears suits except attorneys in Wake County. You just need to be appropriate, no hats. Always tell the truth, maintain your temper, your composure, getting angry, rolling your eyes, shouting at the other person. These are all things that the judge is going to take into consideration when he's deciding who the child should be with most, and what the child's best interest is. So every moment that you're in there, it's sort of like a job interview, and you need to be mindful of that. After the hearing, the judge will make a decision. He or she will probably tell you in court what that decision is. And then they will either immediately or over a period of weeks draft up a formal order stating all of those things that they have ruled on the date of your hearing. It takes time to write these things up, so it might take a while for a judge to get the actual paper copy to you. But you will get a decision and the judge will tell you their decision at the end of that hearing. So whether it's 2 hours or 10 hours, the judge is going to make a ruling and then write it down and sign it, and it will become an order of the court. You can modify court orders. You can modify a temporary order quite easily. A permanent order is going to require you to prove that there has been a substantial change, whether good or bad, that's impacting the children. A little bit harder to modify a permanent order. And that doesn't mean that you and the other party are fighting. It means you lost a job, you obtained a job, you have new opportunities, the children could go to a new school. Those are reasons to modify a permanent order. COVID. A lot has changed because of COVID. Wake County has picked up a lot and added another judge to the rotation, but other counties are backed up. So it can take a long time for you to get in to have a hearing. I can tell you, it's a few months here in Wake. It could be a few weeks. It could be 6 months in other counties. It's hard to know. So things are going to vary. And things are being done remotely now, which is fantastic. So there are certain times when you'll be able to do virtual court. Here, you're not going to be able to have a permanent or a temporary trial virtually. You're going to need to be in court and in person. Obviously, don't come to court if you're sick. I don't think we need to remind you of any of this. Don't show up. The judges will kick you out and ask you to leave if you're in there hacking or you're ill, and they will simply reschedule your hearing. And that is it. Here's all of our information. I have about 10 minutes of time to ask to do a Q&A. So let me just wait until our mediator comes back. Give us 1 second.
Sarah, would you like me to go through the questions with you?
Yes, that would be the easiest. That's typically what I do, if that's okay.
Absolutely, that's fine. If we can, let's just leave this up on the screen so folks can see the phone numbers that they may need and the links that they may need while we go through the Q&A. All right, we're gonna get started again in the Q&A box here on Zoom, folks. So if you have any questions, remember to keep them general, but we can do our best to answer them if you put them in there. The first question is asking if there is any difference, and this was towards the beginning of the presentation, but they were asking if anything is different if the child is only 9 weeks old.
They're just going to have different needs. So there's things that are going to have to be considered by a judge, including breastfeeding, which is a major part of any judge's decision. If you have a child that's breastfeeding, that judge might have to make decisions based on that schedule, so that we have this 9-week-old that needs to be getting this consistently and regularly. That's going to be a factor. So yes, the child's age, no matter what, is going to be a factor considered, and the needs of that child based on their age will be considered by every judge.
Awesome. Another person asks if they would be able to pay with a card.
I don't think so. I don't think you don't pay with credit cards in Wake County. I think you need to bring a check or money order, kind of
Okay.
old school.
Perfect. Alrighty. This person asks, are we able to request virtual court?
Typically not for actual trials. Sometimes the judge might consider allowing a witness to testify remotely. We do have the system up and running, but it's up to each and every judge. It's at their own discretion. And because they're wanting to see your body language and see you live and in person, most of them in Wake County aren't going to do that unless there is exceptional circumstances that warrant it, that require it.
All right. This next question says, what if my spouse does not want to sign or refuses to sign?
If a judge has decided it, nobody signs, the judge signs. And it doesn't matter what anybody thinks. The judge has decided this is how it goes. And if you choose to violate the order, you can get in trouble. If you're at mediation and one of you refuses to sign, if you can't mediate, you can't reach an agreement, that just means it's going to go before a judge. And then that judge decides.
All right. This person is asking, what kind of evidence would be necessary in order to modify an order if the plaintiff has an opportunity to move?
That would be a part of what you're saying is a substantial change. So you're going to want to be able to tell the court all of the circumstances surrounding the move. Why are you moving? Where are you moving to? Is it for a better job? How much does that job pay? Is there family that will be in the area around where you're living? It's not easy to relocate out of state once a custody order is put in place. You're really going to need to show that judge all of the great reasons why they should be taken away from one of their natural parents. So that is challenging in and of itself. But the reasons to modify can be variable, good or bad. The other person has a substance abuse issue, you've gotten a new job, you have opportunities here. It can be anything. It just needs to directly impact the child.
Similar question, this person is asking, what happens when the other parent lives in another state? Is there any difference other than the serving part?
Not particularly, as long as you and the child have been living in North Carolina and it's been 6 months, then you simply serve them, probably certified mail out of state, and they will have the opportunity to come to North Carolina to be heard on custody. But if the child's been here for 6 months, North Carolina is probably going to take jurisdiction of the case and make decisions assuming that the child is primarily living in North Carolina. They're not going to send the child back and forth every week, right? They can't. So if somebody is living 10 states away, it might end up that the child is staying here primarily for the school year and goes to see the other parent for summers and breaks.
Great. This question asks, if you have an order of protection that has expired, will you still need to put that in the form?
If there has been a temporary custody addendum connected to that order, even if it's expired, I would alert the judge to it. They're going to run a search anyway, and if it's in the state, they're going to find it. But if 3 years ago, if you had a protective order and a judge awarded temporary custody, yeah, I would alert I would alert any custody judge to that, even if it's not active currently.
Awesome. We've got a handful of people asking the same question. I'm gonna go ahead and jump in and answer now, folks. Yes, this meeting is recorded. I think we've had 4 or 5 people ask, so this has been recorded. You can access it at any time. As soon as this ends, you'll be able to go to our Facebook page at facebook.com/legalaidnc to access the recording from start to finish. And you can access it at any point in the future. You can do it, in an hour, you can do it a week from now, a month from now, whatever works best for you and your schedule. And you also do not need a Facebook account to view it. You just need access to the internet. Again, that's facebook.com/legalaidnc. The next question asks, can I do this without an attorney?
Sure. That's why we're here today, is because you definitely can do it without an attorney. And the judges are prepared to handle a custody case without an attorney, and the majority are probably without attorneys anyway. So yes, the judge will just be in charge of asking you questions. You'll be able to testify, and the judge is going to ask questions of you instead of an attorney.
All right, we're gonna do 2 more questions, I think, and then we'll be at time. It looks like we're getting a lot of questions about 50Bs and protective orders. And if there's any extra details you can provide on whether or not that affects filing or anything like that.
Obviously, if you end up getting a protective order against the parent of a child or your children, it's probably very important that you're filing for custody at some point after entry of that order, because communications have broken down, that person has become violent or harassing or stalking in some way. You're probably not going to easily work things out in 6 months or a year if that protective order were to go away. In domestic violence court, a judge can enter a temporary order for shared custody between the parents that can last no more than a year. At the end of that year, that thing expires. It cannot be extended or enforceable anymore. And so if a judge does do a temporary order, they're going to probably instruct both of you to go to the clerk's office downstairs and immediately start the process. Because when that goes away, both of you have 100% rights. There's nothing stopping either of you. If the other person wants to go pick up the child from school and spend 2 weeks away, they can do that, and you're not going to have a lot of protection from it. Domestic violence protective orders are also something that any custody judge is required to consider. So if you're having a hearing and a domestic violence judge is writing things down about what happened, your custody judge is going to read all of that, good or bad, against you or for you. And all of that will be not arguable anymore. The judge will say, okay, whatever this judge wrote in domestic violence court, that's what happened, and that's what's true. And they will use that in considering the best interest of the child in custody court. Yeah.
Great. We're going to do one last question, folks. I know that we haven't answered everybody's questions, but we're going to do one more, and then I will review after Sarah wraps up. Last question then is, if a grandparent has temporary custody, what is the process for custody being returned to the parents?
That is a complex question. If you have a person, not a parent, who has custodial rights, that means that you have been found to be unfit as a parent. There's probably a lot of things that need to happen before a judge is going to decide you are no longer unfit. Of course, parental rights are paramount. Grandparents can have visitation rights that don't include custodial rights. You can have a grandparent come in and say, I want to visit with the kids sometimes, and a judge is allowed to consider that and grant it. But if there is somebody other than the other parent who has custody rights over your child, that means that a judge has probably made some serious decisions about your fitness and ability to parent the child. And you should at least talk to an attorney and have it evaluated before you start filing things.
All right. Well, we're gonna go ahead and call it there today, folks. I want to thank you all for joining and thank you to Sarah for presenting as well.
Thank
As a
you.
reminder to folks, you'll be able to access the recording at any time in the future, starting right now, by going to our Facebook at facebook.com/legalaidnc. Again, thank you all for being here today, and we will be back again the same time next month. So if you have more questions, please come then, feel free. And we'll see you guys next time. Have a good one,
Thank
everybody.
you.